Welcome back. You're watching the Power Breakfast Show. Now, in our first interview this morning, we want to focus on the crisis in the judiciary. And in studio, we are joined by Justice Limu Thoga, he's a judge at MITC, together with Counsel Stephen Mugaka. Any questions, comments, suggestions that you may be having in regard to this conversation, 22422 is the SMS line, or you can get us on Twitter. The hashtag is Power Breakfast. For now, I hand you over to Mr. Njao. Mr. Njao?
Thank you, Kirig'o. Welcome, my lord. Welcome, Mr. Mugaka. In your view, Justice Muthoga, how serious is this problem?
Which problem?
The problem that is facing the judiciary. The ruling that was made on Friday, I think that's the cause of the major concern.
This ruling, which was made by my sister Judge Kirig'o. Well, the ruling itself is not what is serious. It is the other tones that go with it. It's the whole process of an abandonment of judicial ethos. See, the unwritten rule in judicial practice is that a judge does not litigate in his own court. What does that mean? It means that if you are sitting as a judge in a court, or if you are sitting in your own court, you cannot institute proceedings before that court. So that, because of course what it means is when you...
That now is referring to Kaparna, the Deputy Chief Justice?
Yes. She cannot institute proceedings in the Supreme Court.
So why was she expected to go?
Nowhere. Judges have methods of redressing their disputes other than through litigating for themselves. If a judge of the Supreme Court institutes proceedings in the Supreme Court, it means he is inviting his or her brothers to make a judgment on himself. Because obviously, if he gives evidence in that court, it will either be believed or disbelieved by his own fellow brothers. And the court doesn't operate in seagulls. It is not Judge Joki Dongo's ruling we are talking about. We are talking about the ruling of the Supreme Court of Kenya. Now, the Supreme Court of Kenya is a composition of the totality of those judges, and any one of them has no business litigating in the Supreme Court.
Which means, in simple man's language, a Supreme Court judge cannot bring a case
in the Supreme Court. Yes, because it's an embarrassment in itself. The law doesn't, there is no place where it's written that a Supreme Court judge may not bring a suit in the Supreme Court. No, it is the ethos of judicial practice that we avoid as judges. We avoid instituting proceedings in the courts in which we preside, because it is a severe indictment and a severe test on the veracity of your colleague, brothers or sisters.
But it has been happening all through. I mean, judges have brought cases in the High Court and the Court of Appeal.
Exactly. So it is because they have lost the ethos, the judicial ethos.
So if a judge is aggrieved,
where
do they go to?
If a judge, for instance, of the Supreme Court is...
No, let's talk about the High Court.
The High Court. If a judge of the High Court is aggrieved, he can resolve that dispute otherwise than judiciary. You know, the High Court is not the only method of resolving disputes. Disputes get resolved in a lot of other ways. So, in respect of his court, he would not institute proceedings against himself. It is just like, it's just downright common sense. But let's go to the ruling of Judge Joki Dongo, which is what you asked me about. I must immediately admit that I don't have all the facts, right? Whatever I have whatever facts I have is what I have read in newspapers. And newspapers, as you know, sometimes don't always tell us the whole truth. So I have to make certain basic assumptions. For instance, they intimated that the stay of the judgment of the Court of Appeal was made within a few minutes.
About 30 minutes.
About 30 minutes
after the appeal
was heard.
Yeah.
It then suggests that in 30 minutes a suit was instituted in the High Court, an appeal was instituted in the Supreme Court, and the matter then came, an application was made in that suit, because you don't make an application in a vacuum. There has to be an appeal in which an application for stay can be made, right? And the judge then went on to hear it without remembering that she cannot issue interlocutory orders or the restraining orders or preservative orders except between parties. They are only issued ex parte on when a number of factors are taken into account. One factor is that it is not possible to serve the other side. They are so far away, or it is very complicated, and the material is going to be destroyed by the time they are served. They are also issued when no other remedy would preserve the status quo. They are issued in those circumstances. In this particular case, there can be no justification for a stay order, in my judgment, because the persons litigating are, one is Judge Raval, and the other one is the Judicial Service Commission. Both the persons could be served within minutes of instituting of proceedings.
In fact, the story is that the lawyers were there, outside.
Yes.
They were trying to contact the same.
Now, Judge Dungu should merely have just ordered that the proceedings be served on the Judicial Service Commission, and then delayed. The Judicial Service Commission is a responsible entity, right? In fact, it's a statutory employer, and is responsible for running matters of the judiciary. There is no chance that they would have retired Judge Raval within minutes, and the transaction gets so complicated it cannot be reversed by an order of the judge. I don't think that is possible. Now, as I said, I don't have all the facts, so some of these facts I'm assuming. I'm assuming that Judge Dungu ordinarily has other work to do. So it can't be that, within half an hour she was available to hear a matter which was not of any urgency at all. Absolutely no urgency, because I can't see any urgency in the retirement of a judge. If all that the Court of Appeal had said, I think, was that it agreed with the High Court, that judges should retire at 7. Again, this is the other aspect of it. A judge ought not to give protective orders without looking at what is being asked and what is the jurisprudence, what is the problem. If Judge Dungu had looked at what is being asked for in this judgment, in this stay, should easily have said, look, there is nothing magical about when judges should retire, because it is written in black and white in the Constitution. But I would like to take this opportunity to clarify something that I have seen the media and other people, including lawyers, unfortunately, saying, which is not correct, which is that a tenure of a judge is preserved by the fact that there was another constitutional tenure. In this country, until 2010, there was no constitutional tenure of a judge. No judge was employed to any constitutional tenure. The retirement date of judges was enacted by an act of parliament called the Judicature Act, and routinely it was amended. In fact, it was amended from 68 to 74 by the work of the great Attorney General Charles Jonjo to preserve the availability of a Chief Justice, James Weeks, whom he did not want to leave the office of. So when James Weeks became 68, the constitution was changed to increase it to 70.
Is it the constitution, the law?
And the Judiciary Act. The determined date. Yeah. Not even the Judiciary Act, because it was being done by a miscellaneous amendments act, by merely saying it is amended to 70. I think first of all to 70, then 72, then 74. Now, therefore, no judge was carrying a constitutional tenure. Every judge was calling a tenure which was limited by whatever the Judiciary Act would say at the time that he is coming to retire.
Let us hear from the lawyer here.
So let me just finish that.
Yeah.
Therefore, when the new constitution came and says judges shall retire at 70, that applied to every judge, whether you were appointed at the beginning of the century or the day before yesterday. You touch 70, you touch 70 years and you retire. And that is the honest and the right thing to do. And Judge Duma would have looked and seen this is an elementary matter, is a matter which I think second year university students would easily deal with without too much difficulty. And there is no reason for it to be given a stay. You would have actually said, come tomorrow or come this afternoon, I will hear the matter. And there would have been there. All these things that we are talking about would not have a reason.
What do you say about that argument from the judge that a judge cannot litigate in his own court, whereas it has been happening all the time?
Thank you. I can't agree more with his lordship because firstly, viewers must see that there are technical problems, clear technical problems with a suit by a judge, particularly when the defendant or the respondent is the Judicial Service Commission. Practically, the Judicial Service Commission is the employer of judges. So to the extent that the suit is against your own employer, that raises issues. How independent can you be as a judge presiding over a suit in which your employer is a respondent? Secondly, where the suit involves a sister or a brother, how independent can you be or be seen to be when presiding over a suit where, so technically speaking, a relative of your own is a party, is a litigant? So although there is no written law regulating how judges and members of the bench should resolve their disputes, there is that inherent problem that every person is supposed to file a suit or be heard by a tribunal that is independent and impartial. So to the extent that the litigation involves both your own employer and your own brother, professional brother, there are inherent problems that whatever the outcome, the justice will not be seen to have been done in that case. And really that is what the learned judge is saying, that it creates an embarrassment, because when your sister brings a suit before you, what are you supposed to do? As a judge, the first business should be to look at it and disqualify yourself and indicate that by the nature of the suit, being known to the party to the suit, I cannot preside over it. So that really seriously speaking, we should not be having any such suits before the court. But here we are, faced with a situation like the one Her Ladyship Judge Ndungu got. The suit arose, is an appeal arising out of a 7-judge bench.
Yeah.
And the question was about, it's an employment issue.
Yeah.
The Employment Act in this republic gives a remedy called reinstatement. And this remedy is given as a final order of the court after you have listened to all the parties. Here is a situation where the Court of Appeal had pronounced itself conclusively about the suit. It is therefore surprising to everybody that then a single judge can reverse, technically reverse the Court of Appeal order, you know, without listening to the other parties. Of course, what the very minimum or the very maximum we expected from Lady Justice Kirig'o was to certify that application as urgent and order that parties be served and even be heard the same day in the afternoon, really, if there was anything urgent about it. But to issue an order that has the effect of re-employing a person who has already been retired really raises serious issues. And where you are dealing with an employer-employee relationship, caution is always called that whenever issuing such orders, let you not be seen as judge to be imposing an employee on an employer, or vice versa, or detaining or forcing somebody to give labor to an employer when such employee does not require, has no interest in that employment. So the long and short is that that ruling by Justice Kirig'o, and to the extent that it fixes the inter-parties hearing day long after another serious constitutional step, being the retirement of the Chief Justice, has already taken place, really creates a serious crisis which needed not to be, because this country is, as we indicate, larger than any one individual, and to that extent, means and mechanisms have got to be created to restore order and ensure a smooth succession in the judicial service, rather in the Supreme Court, as we stand today.
Let's just take 1 minute of engaging our own mind, because it's a very important thing. You don't ordinarily fix the hearing of an appeal or any other judicial matter before it is served, unless there is evidence that service would not be possible, and in that case you ask for substituted service. Here is an appeal which has been filed minutes after the order has come to you. Assuming there was an appeal instituted, because if there was not an appeal instituted, then the order is a nullity, because you cannot stay an order by another court in your court until you yourself are seized of some proceedings. So if, for instance, there had not been filed a notice of appeal by the time this matter
procedurally there need to be a
notice of appeal filed
in the court
and served, right? If that had not happened, then the whole exercise of what Judge Kirig'o did was a nullity. It's a total nullity. But if, let us assume very quickly, a notice of appeal was filed, the questions that Judge Kirig'o would have been asking the parties who brought the matter to him is this. Question one would be this: did you apply for leave for stay in the court that made the decision?
Yeah.
Question one.
That is the Court of Appeal.
Yes.
Did you
apply for a stay?
Yeah.
Because regularly you would apply for a stay in that court, and you would not go to the Supreme Court
to apply for the same
to apply for the same stay. And then if in the event that the answer was no, then the judge should have just said, go back, apply for a stay in that court, because that court was seized of the matter, and competent is seized of the matter, and that court is not an inflicted court, because Judge Laval is not a member of the Court of Appeal. And Judge Dungo would have got rid of the file from her desk. But let's suppose they said, yes, we did, and the stay was refused. If I was in Judge Dungo's position, I would have said, if the Court of Appeal has refused you a stay, then come to this court by way of an appeal against refusal of stay. Now, notice the difference.
That's the difference, yes.
There is the appeal of the order of the ruling of the decision of the appeal of the court, which in my view cannot be canvassed in the Supreme Court, and it is not without reason why it can't be. But there is appealing against the stay. Now, if that appeal were then to come to Judge Dungo, she could competently decide it, because it doesn't require that anybody, any judge, any brother of hers, make any dispositions before her. And it's a technical procedural matter. But here we are. She stays a decision of the Court of Appeal. And remember, this has a decision which has a history, because in the High Court it was heard by an extra large bench of 5 judges, I think. Yes. If I'm right, my memory is correct. It was heard by 5 judges. Then it comes to the Court of Appeal, and it is heard by 7 judges. The only reason it was treated with that gravity is not the seriousness of the business, it is the status of the litigants, right? The Deputy Chief Justice versus the Judicial Service Commission. That status is what sent judges. And for one judge, even in the Supreme Court, to think that how many? 5 plus 7 is 12. 12 judicial officers, all right? People who are trained lawyers and judicial officers have actually applied their mind to this matter. But I actually think they probably erred. They made a mistake. One ought to worry very much about that judgment, that decision themselves. Want to worry very much. And this is the kind of thing you would shy from dealing on an expert basis. You would like to be addressed. Let's hear these addresses, because if 12 judges have actually and unanimously, and I think both decisions were unanimous, if they have seen it this way, it may very well be that they are right. They are more likely to be right than wrong. So instead of doing it ex parte, in a way, if you accept what the newspapers put, is like there is a hide and seek game going on, because as you have said, some of the people who were supposed to be representing the Judicial Service Commission were present on that. Then it puts such a huge scandal on my Lady Judge Dungo, that her retirement from her resignation from the Supreme Court is almost an inevitability. Inevitability, because you can't do that honestly. So we must come to the conclusion that she has acted with motives that are less than honest, and she has taken an oath of service to administer justice without fear or favor, affection or ill will. So if in fact she could do a chini with justice, then her retirement, leaving the office of judge of the Supreme Court is almost an inevitability.
Maybe let's go to another thing.
Just because maybe rather than look like we are really bashing our leadership, we need also to take cognizance that the Constitution does provide that at Article 159 that justice need not be done, through looking at technicalities. Let's also be lenient to her ladyship that maybe she did not need to look at the technicalities involved, because the Constitution also does give her a window to do that. Let's also give her the benefit that looking at the suit that was before her, and she's faced with a situation where her sister is being sent on an immediate retirement. And let us also look at her mind going through a situation that the Chief Justice is retiring on the 16th of June, leaving no Deputy Chief Justice to fill that position. And faced with that scenario, applying her mind, she may have been looking at it that the best public interest is there is no hurry in retiring the Deputy Chief Justice when the Chief Justice is retiring in another 2 weeks. Let the country have a Deputy Justice for the time being until the issue of employing another Chief Justice is resolved. So as much as at the face of it, it may look that she acted in a manner that was not expected, she may, applying her judicial mind, have been acting in a manner that saves the institution of the Supreme Court rather than create a bigger crisis. Yeah.
But surely, Mr. Jau,
yes,
that is the arguments that she would have hoped to receive from the parties coming to argue before her. She doesn't wait for those arguments. She would not be, a judge cannot manufacture reasons for a decision. The parties come, they tell her, look, judge, the Supreme, I would have expected the Judiciary, the Judicial Service Commission, all the other people saying, look, judge, we are in this crisis and we really think this matter is so important, it should be stayed because of this and this and this and this. And then she can decide that. Now, if she doesn't decide that, all right, if she doesn't hear the parties, he hears only one party, and then obviously the urging of it, I personally suspect it can't have been that this country needs the Chief Justice so badly, the Deputy Chief Justice so badly, don't send us, keep us without a Deputy Chief Justice. Because in any case, Chief Justice herself isn't available to be either Chief Justice or anything else. You can't do what she has done and then expect to be able to hold the office of an office of Chief Justice, because it's grounded on honor. And an office which is grounded on honor cannot go to the hearts of somebody for whom honor is difficult to justify. I mean, I can't.
But with tremendous respect to his lordship, no judge makes a decision based on her own thinking. There was counsel for the Deputy Chief Justice who moved the Supreme Court judge, the single judge, and made submissions that were the basis of granting that order. So to impute that the judge gave that order on her own motion, I think is the wrong way to. I
wish to correct that.
To think, yeah, because there were two submissions. Indeed, it was not ex partis, but based on the submissions of the counsel for the Deputy Chief Justice, that was the basis on which her ladyship gave those ex partis orders. Whether or not the orders were merited, really in judicial practice, rather in legal practice, that is a matter for the inter-parties hearing. But what we are looking at is the implications of those orders. And what I would want our viewers to get is that, yes, the judge gave those orders. Lady Justice Njokindumu gave those orders. But those orders were upon the submissions of counsel for the Deputy Chief Justice. And depending on what those submissions were, she was convinced in her mind that the matter was urgent, and gave the orders, preserving the occupancy of Justice Kalpan Rawal in the office of Deputy Chief Justice.
Let me correct that I did not at any time say on what basis the orders were given, because I don't know. I have admitted that I have no facts beyond the newspapers. But it is a theory that he said that she could have looked at this and seen the countries in a parade and so on and so forth. And obviously, if that is what was argued before her, before accepting that, she would definitely want to know about, from the person who is responsible for managing the judicial service, and that is the Judicial Service Commission, because they have the best argument as to how to manage the succession, how they plan to manage the judiciary without a Chief Justice and a Deputy Chief Justice, which is what they were asking for. They were asking the inevitability of it. But if she actually felt persuaded that there is an arguable case that can argue that a judge is 70 and does not have to retire, in my respective submission, she would have waited to have that argument placed before her by a party to those proceedings.
Now, the dilemma that we are is it was done. The Judicial Service Commission is supposed to have a emergency meeting today. If you are in the Judicial Service Commission today, having seen that, what is next?
What would I do? It will depend on certain things. Then let me assume the facts so that we can argue on them. I would look to see whether in fact there was an appeal on which an order of stay could be based. And I would say if there was, then we have to look at the order of stay. And all I would say to the Chief Justice, to the Honorable Chief Justice, there is no reason why this matter cannot be heard tomorrow, because it is not a matter which requires any evidence. It's a matter of purely arguments on the law, and the court can issue, the Chief Justice can issue an order that it will be heard tomorrow. All the parties stop whatever else you are doing, come and hear this important national matter. And that's what I would be advocating if I was sitting in the Judicial Service Commission and if indeed there was an appeal. If in the possible position that there was in fact no pending appeal, then I would tell my colleagues and Judicial Service Commission this meeting is a waste of time, because in fact the order is overnight. So let's go and do some other work.
What did you say? I think as the Judicial Service Commission served with that order, the correct procedure in law is to instruct their counsel to move the court to apply for review of the orders given by Her Ladyship Justice Njoki Ndung'u. Given the circumstances, going back to Lady Justice Njoki Ndung'u through an application for review of the orders, Her Ladyship may reconsider the position and vacate those orders and or fix the matter for hearing at an earlier date than she did. The other alternative would be the counsel for the Judicial Service Commission to actually make an urgent application asking the Supreme Court to vacate the orders given by Her Ladyship Justice Njoki Ndung'u, because as much as the ramifications of the orders given by Judge Ndung'u have far-reaching impacts, it is also important that the law be observed in vacating an order that has been given by a court, because there is only one way to deal with that order. It is either it gets reviewed or vacated, and there are sufficient procedures in law for achieving that. We also think that it would be important that holders of public office in this country relook at the manner in which they are conducting themselves while claiming their right to hold such offices. Because if by holding a certain office, you know, you are hurting the larger public interest. I think it's incumbent on all public officers to really take a self-look at themselves and consider their actions as much as their own individual rights and interests in holding public offices and the remuneration and perks that go with it. It is also very critical, and it is indeed provided under Article 73 of the Constitution. Every public officer is required to bring honor in the office they hold. It does not make sense, you know, pursuing the parochial remuneration interest or the glory of occupying a public office when, by so doing, it is hurting the larger public interest. And really, this is why, as media, we really need to scrutinize holders of public office, and where their continued stay in that office is untenable. It is really important that we start seeing in this republic Kenyans giving up those positions, you know, to bring honor both to themselves and the offices that they are seeking.
Final one before we close.
The problem with going for a review of that order is this. First of all, that review would have to go to Judge Kirig'o. You would have to show that a new matter has arisen, which was not in the contemplation of the parties when the order was made, which you did not know about when the matter was made, which then requires her to review her own decision. I cannot see some basis where you would say that a new and important matter has arisen since the order was made. So I don't see why she would want to review it, or she would review it. I agree with my colleague that it is very, very, very important that public holders of public office recognize the import into which their offices have in doing it. If you read the Constitution and understand it, your own personal convenience should be completely disregarded. We serve, as judges, we serve the public good. And in the public good is that I go home, then home I should go. This crunching onto possessions of authority and actually even taking steps that are not honorable to retain them is wrong. And media should actually say so. It is wrong because we cannot advance this country without integrity. Integrity is the highest requirement of a judicial service order.
Thank you very much, Your Lord. Thank you very much, Mr. Mbak. I think we have that reference about public office also. To me, I understand it to mean including the electoral commissioners. Thank you very much.